Disclaimer. The comments made in this video are intended solely for entertainment purposes and are not intended to harm or offend anyone.
From a defendant insisting the drug in his system was a mistake.
And then he comes here in court to say that I'm going to see this miracle test saying that the cocaine wasn't there, when we've already had 2 tests that say that the cocaine was there.
To another, admitting her assault charges.
Yes, they started it, but I ended it, and I'm guilty, and I want to say I'm guilty.
Here are 4 moments where Judge Simpson crumbled flimsy defenses and held defendants accountable in the face of weak excuses. Starting with Mr. Gambari, accused of using cocaine, which is a violation of his bond conditions. He was tested positive for cocaine and opiates.
We're here for a pretrial. Mr. Gambari also has a pending bond violation. Yes. I did get an updated report from Ms. Kerr today. Mr. Gambari is asking for an adjournment of the bond violation hearing. He did send out the test, and it did come back positive. However, he says around this time, he did a test at the hospital. He takes narcotics for his some medical conditions that are prescribed. They do drug testing consistently there to ensure that he is taking them in accordance with therapeutic processes. And he reports to me that he believes that test that was done at the hospital would come back negative. He just has not received those results yet.
When is that test?
He says that test was around the time of October 1st. Is that right?
Yes. So is he indicating there was a test that came back that the cocaine is a false positive?
He is.
Really?
He's saying that he did not consume cocaine, and he believes this other test will show.
So when that test was sent out, it came back positive.
Yes, they sent it for a review.
They sent it for a review, and it came back positive for cocaine.
Correct.
So now there's this other test that we're supposed to get, but we don't have the results that are going to show what?
He believes a different result than the test that was done at community
A
corrections.
different result, like no cocaine?
Correct. He denies, Your Honor, that he consumed any cocaine. He denies that he consumed any cocaine. He does have a list of medications that he also tested positive for opiates. He does have a list of medications that he provided both to community corrections and to me that do include prescriptions for opiates. I know the court is more concerned about the cocaine, as there's no medical reason to consume cocaine. But again, I can only report to the court that he maintains that he didn't use cocaine, and he wants to prove it to the court using this other blood test. We've spoken quite a bit about this, and he denies any use.
The audacity of this man to claim the result is a false positive is wild.
He is asking that he not be remanded today. He again does want some more time. He has a eviction.
When was this blood test or this test at the hospital?
Oh, he was in the hospital around the time of October 1st. He has an after visit summary. He was at Trinity Health on October 1st at 10:30. On that date, he did testing. And saw his doctor for his medical needs.
And we don't have the test results back yet?
Yeah.
No.
When are they expected back?
Just give it time, I can get it back.
He says he just needs time.
It's crazy how this man thinks he can just cook up excuses as to why his so-called different results aren't here and expect to be believed that he didn't take cocaine.
When are they expected back?
Do you know when they're coming back?
I can get it today, tomorrow.
Pardon?
I can get it today.
So you could have gotten it yesterday and then had it here.
I didn't know that. I have to click it.
He says well, but Your Honor, he does want me to tell you that he does have a hearing on his an eviction proceeding hearing today. He is concerned that he's going to be evicted if he is remanded at this time.
No lease. I have to sign in my new lease. No eviction.
Where do you live? Ann Arbor.
Yes. And I have to sign in my new lease. I don't have an eviction.
He doesn't have an eviction hearing
You have to sign-
because they do those on Tuesday.
Okay, I'm sorry.
Today's Wednesday.
I misunderstood. He has to sign his new lease
Yeah, I
today.
have to sign in new lease.
Well, Judge Simpson is not falling for these crappy excuses.
At the same time, I have to be on a court today at 2:30 for I'm victim and for the accident my damage my property.
Oh, okay, I'm sorry. He is the alleged victim on another case at 2:30 today
I'm a victim.
Where?
for damage to his property. Wednesday, 2:30, before Judge Garwood, Magistrate Garwood. It is a small claim.
It's a small claims. It's a civil action. Okay.
So, Your Honor, again, he's asking for an adjournment.
But he could have had his
For more
test
time.
results. If you want me to wait for, he could have had him here today because he just has to get them from the hospital. But he didn't do that. And then he comes here in court to say that I'm going to see this miracle test saying that the cocaine wasn't there when we've already had two tests that say that the cocaine was there. Have I summed that up correctly?
Your Honor, I don't know if, I don't want to, this is my assumption is that Mr. Gambari was waiting to hear the results back from the sent out tests. Miss Kerr did send up, I called her this morning and she said, oh, I didn't realize I had the results back. So perhaps he was waiting for those results to come back before getting the other tests because
Oh,
he maintains that he doesn't know where the cocaine is from.
okay.
The fact that he just doesn't want to admit that he messed up is annoying.
People.
Your Honor, this is an authorized second offense.
I know.
First offense is from 2018, and it involves a crash to a building.
You should, counsel, sign a release for you so you can get the test from the hospital. But at this point, the defendant's bond is revoked. Defendant remanded to the jail. I'll adjourn this hearing to November 6, 2024, 9 a.m.
As expected, Judge Simpson wouldn't tolerate this. Mr. Gambari got what he deserved for taking during his bond. While Mr. Gambari persistently denied his offense, Judge Simpson faced another offender who violated the no-contact order against him.
All right, 14th District Court is now back in session. Honorable Judge James Simpson presiding.
Don't talk to, you may be seated. Don't talk to. That's what our whole meeting was about.
I'm just working to get you out of here.
I thought you said you were done.
I was done with my antics, Your Honor.
Oh.
I thought that's
And now I'm done. I'm done. Which is,
I honestly do not know.
okay, good enough. Court calls the case, People versus John Waddell.
Assistant Prosecuting Attorney Morgan Priest on behalf of the people.
Good afternoon, Judge. 76343 on behalf of Mr. Waddle. President, would you say your name, sir?
John Waddell. And, all right, what are we doing?
Judge, I think we're going to try to set this for a preliminary examination.
Discovery is complete,
Yes.
and would the people have their witnesses available the 5th?
Judge, I'm not available the 5th, so I was going to ask for the 19th.
Yeah, what happens to people when they ask for dates? Mr. Bellinger? Never mind. Will that be acceptable to the people? The 19th. Preliminary examination will be set November 19th, 2024, 9 a.m. That is before Judge Barr.
There are some issues regarding bond that I do hope to address with the court.
Yes.
And I was made aware of them earlier today, Judge, just so you're aware.
It's come to my attention, Your Honor, that the defendant has
in my opinion, been violating the no contact order. I understand the court might perceive it as towing the line. However, he has sent a package with a note to the victim's residence. It's my understanding that the defendant characterized this as sending it to the kids. However, the note in it said, "I love you all so much. Love someone who loves you more than you could possibly know," or something along those lines.
This man's behavior is enough to piss anyone off.
And then there's the additional incident of the defendant at least once being seen driving past the soccer fields while the child in common was in practice, after I believe the court explicitly stated that he was not to be at sporting events while the victim was present. So I am concerned at this point. This does seem to be, in my opinion, multiple violations of the no contact order. And I wanted to raise it.
Judge, he did send a package to his kids, which was just blankets for his kids and a note directed to his kids. Granted, the package was addressed to the complaining witness, but
Excuse me?
the package was addressed to the complaining witness, but it was just for the kids. He sent blankets to the kids. And then as to the,
When was that?
I don't,
Your Honor, it was ordered, I believe, on the 19th, but I do also want to put on the record that the victim moved and the defendant had to go to great lengths to find out where they relocated to. So that is another reason I'm concerned. She did not share her new location with the defendant. She did not want him to know where she lived.
To think this man is stalking his ex and is trying to claim innocence is outrageous.
The 19th, you said?
Let me confirm one moment, Your Honor. Ordered October 16th.
What was ordered October?
That was when the package was ordered.
Gotcha. How old is the child?
there's 3 children, Judge. How old are your kids?
7, 8, and 9.
7, 8, and 9.
So why was the package addressed to, well, a couple things. What was the purpose of this?
To send something to my kids because I'm not able to contact them. And it's just something I knew that they would enjoy.
So
I was told that I wasn't able to contact her, and I was trying to abide by that and just send it to my kids. I addressed it to her, not.
why did you address it to her?
It was just something that crossed my mind because it came up as that address. I didn't mean to.
What do you mean if it came? I don't know what that means.
I didn't mean to address it to her. I meant to address it to them. I just didn't think of that part of it.
Excuse me?
I was trying to
You
send
meant to address it,
to my children.
Corporal? You what?
He meant to send the package to his children.
So why weren't their names on the package?
Because it was meant as a surprise, because they all had different blankets that they enjoy. And I couldn't leave it blank.
The judge at this point probably can't believe how creepy this man is right now. And to make matters worse, he wants to play the I'm innocent game.
I was just trying to send something to my kids. I wasn't trying to disobey any rules. And this is all new to me. I haven't done this before, and I was just trying to send something to my kids.
Okay. How'd you find their address?
So when I was able to move back into my house, the power was off. So we have a list of accounts that we have at our house. And so I got onto DTE to turn it back on, and that's when I saw her address, because the account was used. She used the same account. So I paid that off, and then it was said that I had to create my own account. So I logged off and created my own account. But her address was on there when I logged in. So I paid that bill and then logged off and created my own account.
So prior to doing that, you didn't know where your kids were.
I did not. I didn't do it to find them. I had to turn the power back on my house, and I went to where I knew I had to go.
Having so many excuses for all his actions instead of taking responsibility is unacceptable.
And so once you see that,
Yes,
then you decide to send the package?
to my kids, yes.
But Your Honor, there were 4 blankets sent, and he has 3 kids. So I don't really understand how that's going either.
All right, I'll ask the $1 million question. You have 3 kids, you're sending them a blanket. Why'd you send 4? Please, you know what?
I don't.
Think about your answer to me. I look stupid, but I'm really not.
It's just all what we used to do at our house when we lived together. They all have their own blankets, and there's an extra one that they use. My son wets the bed a lot.
Oh, hold it. So what you're telling me is you sent 3 blankets, 1 for each of the kids, and then an extra.
Yes, because my son wets the bed a lot, so he needs an extra one.
You gotta be kidding me. Is that your story?
That's what
you're gonna tell me.
I don't know what else to tell you. I wasn't to my wife.
Well, the truth would be okay.
That's all I have.
Why'd you send? I'm gonna give you another shot. Why'd you send 4 blankets?
That's what I have because that's what we do at home. That's what we did before. That's how I know what she's done, because she's told me. Because my son's extra blanket is actually on the bed at my house right now.
Judge Simpson is completely pissed off. I mean, does this man expect anyone to buy those crappy excuses for what he did?
Like, she made the bed when she left and it's still there.
Okay, what about driving past sporting events that she's at?
It's my understanding, but I'll let him explain it.
No, go ahead, Counselor.
He was driving his work truck from work to a auto parts store in the same city, and then drove back to work right after that. So I don't think he stopped or drove by slow. I think he just happened to be, and I don't think he even knew. He told me earlier today he didn't know. He knew the kids had practice, but he thought they were not at practice.
Just so I'm clear, you addressed the package to the alleged victim in this case, have 3 kids, so you know that there are 4 people that are in that house. You sent 4 blankets, but are telling me they were all for your kids. I miss anything?
No.
Counsel, do you want a hearing on this? As to a bond violation?
I mean, I guess maybe, do you know were the 2 of the blankets the same, or? If you know, I don't know if you know or not. I don't know.
I don't, personally, it doesn't make a difference to me. There's 4 blankets, 3 kids, 4 people in the house. Package is addressed to the victim. That doesn't make a difference.
Judge, I think we don't need to have a hearing.
Okay, let me ask you this, because I'm about to revoke his bond. So, do you want a hearing on this, Counsel?
Yes.
I figured as much. All right. I'll leave the preliminary exam date. I'll set a hearing. On his bond violation. Can everybody be ready next week? Might be appropriate we do it on Halloween.
Judge, I can't do it on the 31st. Unless we do it, or I guess I could do it right at 1.
Right at 1, yeah. You don't know how my days work.
Oh, I know,
But
I
mean,
know.
I can, well, we normally set it at 3, but I don't know if that's gonna cut later causes you a problem.
Yes.
So,
I just had something at 10 and 3. So I was like trying to,
there's no way for me to predict what that docket entirely will look like. What about the 7th?
I'm in an assault with intent to murder trial that should be ending at that time. So I think we could schedule it that day. I should be done.
All right, I'll set a hearing on his bond for November 7th, 2024 at 3 p.m. I'll still leave the exam date in place. All right,
Thank you, Judge. So it'll be here at 3 p.m.
3 p.m.
Thank you.
All right. On that date, at this time, given what the court has heard, defendant's bond at this time is revoked, defendant's remanded.
Judge, can he have some sort of cash bond with maybe a GPS tether just to allow him to continue working? He was living at his job until recently. He had to move when he moved back in the house.
Revoked his bond.
I know.
No, I understand what you're asking, and I'm going to deny that request at this time.
Okay.
All right.
Thank you, Judge.
Well, as expected, Judge Simpson wouldn't let this slide as is a threat to the victim. Ms. Nan Wesley here is facing serious charges related to multiple instances of operating a vehicle while intoxicated, which is classified as a 4th offense.
Court does call the case, People versus Nanny Wesley.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Ms. Wesley. Nani, can you please state your name for the court?
Yes, my name is Nani Wesley.
Your Honor, we're waiving the preliminary examination. I know there's a bond violation hearing that needs to be addressed.
Yes, you need to address that now.
Your Honor, she will be acknowledging and admitting to the bond violation. And hopefully I can say a few words after that.
Go ahead.
Your Honor, I did submit some documents to the court. Hopefully Your Honor has had a chance to review those. She's been treating with the Home of New Vision since about April of this year, and she attends AA meetings pretty regularly. Nevertheless, this is...
When did you send documents?
Yesterday, Your Honor.
Okay, go ahead.
That looks like one of them. She's been treating with Home of New Vision since April. She's going to AA quite a bit. It is a struggle, though, Your Honor, and she admits the struggle. She has gone back to Home of New Vision. She has spoken with them. She's told them about what's went on. They're giving her some things to do to redouble her efforts. I'll just give Your Honor a minute to read if you'd like.
Go ahead.
They've had her go out and get a sponsor. She's been working with a sponsor now. I've attached a letter from her, Your Honor. She's really been pushing Nani to get new strategies in place, new ways of dealing with things, new ways to address her thoughts and behaviors as it relates to drinking. And she appreciates that pushing from the sponsor, Your Honor, and she can tell you that as well.
Go ahead.
She has been putting in some very serious hard work, Your Honor. We're hoping that the court can take that into consideration and please give her a second chance at this, Your Honor.
Most of them repeatedly violate their second chances.
She went to Home of New Vision again this morning, and they hooked her up with a recovery coach. She gave me her card from her, and she says that they've been also giving her new strategies as well in dealing with this. So she does admit the violation, Your Honor. She is a bit ashamed of herself, given that she's trying to put in a serious track record to get to this point. But she's dealing with it as proactively as she possibly can.
Well, then when it was asked about, why didn't she just say what happened?
Freaked out, got nervous. There's no good excuses for it, Your Honor.
Well, but there were numerous times she could have, like a better term, just come clean on it. She didn't do it.
It's hard.
It's not like they just asked her once and they wanted her to take an ETG. And she sat there and skirted around all of that.
She got scared, Your Honor.
Miss Lundy, anything?
Your Honor, the concern of the people here is that this is a true fourth OWI. Priors in 2005, 2015, and 2018. The alleged BAC at the time of the stop for this case was a .214, and we have a confirmed drinking event while she's on. The public safety risk this defendant poses is extremely high. People are concerned that if she's not put on a scram, or if there are not other steps taken to make the public safe about what might happen. This event, fortunately, it seems like it is being taken seriously. History of the defendant with alcohol cannot be ignored by the people. We are requesting either a remand or a scram tether installation before she leaves this immediate vicinity.
If she truly wanted to change, she wouldn't be back in court for getting high and giving different excuses that just don't make sense.
How come she didn't take the ETG?
Right then and there, Your Honor.
Hmm?
Right then and there, Your Honor. She did take the ETG. It came back to on-site.
At what point?
I don't know that, Your Honor. Yeah, you of course can talk when the court's ready for you. Yeah. Are you asking Ms. Wesley?
I'll hear from her.
Okay.
Your Honor, I did take it the same day that I was asked to take it. I wasn't in town. I told her I wasn't in town, and she said that I needed to take it, which I did do. I came back to Ypsilanti to take it. I was not in the area.
I guess my question, you took it on what day?
The same day that she requested the 3rd.
Why didn't you tell her you did?
I did tell her, Your Honor.
When?
I told her,
What? Okay, let me ask this. Why was your story changing?
I was nervous when she called me, and I told her that I wasn't in the area right away. And she said, well, where are you? And I said, I'm out of the area. I'm up north. And she said, well, your device isn't up north. It's in Detroit. And I told her that I would come back if she needed me to. And she said, well, I can give you some places where you were at to test. And I said, I will try to make it back so I can do so. And I did do that. I did it the same day she asked me to.
Your Honor, if I may, the report that I received does indicate the testing was done on-site, not community corrections. And I also have that same information, I think the court has as well, where the initial information that's provided by the defendant to community corrections is that she was up north and unable to do that. But that 20 minutes before this contact, GPS and SovLink said she was in Detroit. And then the defendant said she didn't have it with her, SovLink.
I didn't physically have it with me, Your Honor. I wasn't with the SoberLink. That's what she was asking me, the corrections officer. And I told her.
Where up north were you?
In Dryden, Michigan.
In where?
Dryden.
So, Your Honor, I mean, bottom line, she did come back to do the ETG knowing that it would be positive and knowing that this court would take that into account. She has been scrambling this past week to try to get things into place. I think with everything she's been doing since April, with what she's doing now in combination with the scram tether would keep her on track, Your Honor.
How is that going to keep her on track?
It'll make sure that she can't drink.
No, she can still drink.
Well, tell her she does.
Drug addiction isn't easy, but this woman here did nothing to help herself at all and is trying to avoid jail time.
I promise you.
Much like this did. And then when they call her on it, she starts all kinds of excuses, Mr. Allen.
I'm begging you, Your Honor, I will not. I have, at the time, did not have a sponsor in place. I have a sponsor now. I'm working with Home of Envision on a weekly basis. I see the treatment coordinator. She did submit a letter to say that. I told her right away.
Ma'am, this is the 4th time. Then you get caught the 4th time. You're almost 3 times the legal limit. You get a bond, you're out. We put you on a sober link. You drink. Then when you're called on it, you begin this whole thing of going around it and everything. And that's what gets you into treatment.
Well,
So what you want me to do is you want me to take the chance of putting you on a scram tether, allowing you to get behind the wheel of a car, maybe having drank,
Your Honor.
and hurt or kill somebody. Not going to happen.
Your Honor, I won't do that. I have.
Bond revoked. Defendants remanded. I'll adjourn this out 1 week.
We are waiving the preliminary examination.
I'll
Your Honor.
adjourn it out 1 week. She can do the waiver then, but she's going to do this now. October 24th, 2024, 9 a.m.
The general public is at risk if she's not sentenced, so let's hope being in jail makes her learn and seek help to stay clean. Ms. Valentine here is charged with 2 counts of assaulting prison employees, yet she insists on defending herself in court.
Court calls case People versus Rebecca Valentine.
Good morning, Your Honor. First, Public Lena Anderson with and on behalf of Ms. Valentine. Ms. Valentine, please state your name.
I'm defending myself, Rebecca Valentine, and I want to enter a guilty plea.
Excuse me?
Your Honor, I spoke with her this morning. She advised me that she wanted to represent herself and did not wish to be represented by the Public Defender's Office.
Is that a correct statement, ma'am?
Yes.
All right. Couple things we have to do here then. I do have to advise you that you are before the court on 2 charges of assault on a prison employee. Do you understand the nature of those charges?
Yes, they started, but I ended it, and I'm guilty, and I want to say I'm guilty.
Ma'am, I'm also going to advise you that you should refrain from saying anything about the offenses, as anything that you say can be used against you in this matter. You also understand that each of these counts is a felony, punishable by up to 5 years incarceration and a $250 fine plus court costs. You understand that?
Yes, I do understand that.
All right. You also understand that there can be great perils in representing yourself in this matter?
Yeah, but I accept that. I don't really think there's that many perils.
You also understand that in doing so, that you would be held to the same standard that an attorney would be held to regarding knowledge of the court rules and knowledge of the proceedings.
That sounds pretty fair.
All right. So your intention is to represent yourself in this matter?
Yes, sir, and plead guilty right now.
You understand, you could please not interrupt me, but if you understand also that if at any time during these proceedings that you wish to be represented by counsel, that you can request that of the court, and the court would appoint counsel to represent you if you could not afford to hire counsel. You understand that, ma'am?
Yes, sir.
The audacity to be this confident after committing such a crime with no remorse is outrageous.
And so you wish to proceed today without counsel, is that correct?
Yes.
Public defender is permitted to withdraw as counsel of record, defendant to represent herself.
Thank you, Your Honor. Do you need an order?
Pardon?
Do you need an order?
Please.
I'll get that to you right away, sir.
Okay, ma'am, what do you wish to do today?
I would wish to enter a guilty plea.
All right. If you wish to enter a guilty plea, you're going to have to waive your right to a preliminary examination, proceed to circuit court, and enter the guilty plea there.
Okay.
So you wish to waive your right to have a preliminary examination in this matter?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah.
You understand that you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
People also waive their right? Preliminary examination having been waived, defendant is bound over to circuit court on both counts. Ma'am, you understand, and it has not changed from the time of your arraignment to the time that I just read the charges. You understand that this is, at this point, the circuit court arraignment. You understand that, ma'am?
Yes, sir.
The information in this case alleges that on or about November 26, 2022 at Huron Valley Correctional Facility, count 1 alleges that you did commit an assault on a prison employee, that being a Tracy Maupins. You understand that charge?
Yes, sir. I punched her in the head 3 times.
Excuse me?
Yep, I did it. I punched her in the head.
Well, you understand what you are charged with.
Yep, punching her in the head.
It's as if she wants to incriminate herself further. This woman needs help and she doesn't want to accept she's a mess, or better still be mute.
It's a felony punishable by up to 5 years incarceration and a $2,500 fine plus court cost. You understand that, ma'am?
Yes, sir.
The information also alleges that on that same date at that same location, that you did commit another offense of assault on a prison employee, that being a Lauren Hales. You understand that charge, ma'am?
Yeah, I punched him in the head 3 times too.
I'm also going to advise you that you should refrain from saying anything about the offenses in this case, because anything you say can and will be used against you. You understand that, ma'am?
Yeah, but I'm already saying I'm guilty, but I understand.
The second offense is also a felony punishable by up to 5 years incarceration and a $2,500 fine plus court costs. You understand that?
Yes, sir.
You also understand that, as I had indicated before, that you do have the right to be represented by counsel. You cannot afford to hire counsel. You would be appointed counsel to represent you. You understand that?
Yes.
All right. This time, ma'am, what I'm going to indicate is that you're standing mute to these charges. That means you're not at this time saying anything about them, and I will be entering a not guilty plea. You understand that?
No, because I want to say I'm guilty. And I thought we found it over to circuit court, so
Ma'am, you understand that for the purposes of this arraignment, you're not saying anything about them, meaning that you're standing mute. By law, that means that the court will enter a not guilty plea on your behalf. You will proceed to circuit court, and then you will do what you wish.
Oh, I thought we just switched over to circuit court so I could do that.
Well, at this point, Judge Simpson is trying to save her from herself, but she's too arrogant to calm down. Seems like there's more to this attitude of her wanting to go to jail for this.
Well, we kind of did. But I'm not doing the plea. The fact that you don't understand may be why you need an attorney. But
I don't need an.
I can't force you to have one, so you're going to proceed on your own. Do you understand what I have just said?
Yep, you're not doing what I said.
Or will indicate the defendant is standing mute to both charges. I'll enter a not guilty plea. Pre-trial in this matter will be set for
November 13th at 1:30 before Judge Conlon.
good luck. November 13th, 2024, 1:30 before Judge Conlon, and I'm sure Judge Conlon will be more than happy to take your guilty plea, ma'am. All right?
Okay.
Bond in this
Have a
matter
good day.
will continue. Thank you.
Thanks.
Excuse me one moment. Ms. Anderson, thank you for all the help on that. That's really appreciate it. You got away from that podium faster than I've ever seen you move. All right.